Welcome to American History Notes, where I discuss things I've learned about American history, um, and things that you might be interested in, and I hope you will be, and you'll investigate them further on your own. And and disagree with my conclusions is fine, but have your own conclusions from your own study. So, we're talking about colonial criminal justice and colonial America. It can't be separated from colonial religion. Adultery, heresy, blasphemy, and being a Quaker or an Anabaptist and not allowing a standing order minister to baptize your infant were all crimes under the Puritan Code. You could be fined for not attending church regularly in both Massachusetts and Virginia, and you could be fined for misbehaving in church. In Boston in 1656, a man was placed in stocks for profaning the Sabbath, that's Sunday to them, rather than the biblical Sabbath of sundown Friday to sundown Saturday, by kissing his wife after seeing her after a long absence. In general, the colonies made little distinction between sin and crime. This is our present mindset as well, as most people think that if something is legal, that it's all right to do, and conversely, if something is a sin, it should be illegal. It's difficult to wrap our minds around the mindset of our founding fathers that some things that are wrong are simply not the purview of government and not regulatable within the framework of just government. Religion was the cornerstone of the colonial community. There was no concept of today's victimless crime. Sin was simply illegal. Lying, idleness, homosexual behavior, fornication, and any sexual practice between a married couple that did not fit in what was believed to be biblical boundaries by the standing order was illegal. A pedophile was put to death in 1646. In 1642, a teenager who confessed to bestiality was executed, and the animals killed as well. Women who bore illegitimate children, called bastards, were whipped or fined or put in stocks. In spite of the thousands of cases of court records of charges of fornication, most people, historians record, tried to live well behaved and moral lives. Whipping was a common punishment, especially for servants and slaves. Servants bound for a period of time could be forced to serve double time if they ran away. There was no such thing as probation, and offenders were often required to put up money to ensure the society of their future good behavior. There were cases of a person being found innocent of a particular crime, but because of their lifestyle, being forced to put up a hefty bond to guarantee their good behavior for a period of time, like a year. These were tiny communities by our standards today, and everyone had a stake in an orderly and decent community, so posting of bonds did work. The ultimate aim of colonial courts seemed to be confession and repentance. Adultery was often a capital offense, punishable by death, but this was rarely enforced. Other capital laws, with bark and no bite, were the death offense for being a disobedient son, cursing a parent, etc. And English law was more quick to pass out a death sentence than was colonial law, according to the most historians I'm reading. Unlike in England, property crimes were rarely met with the death penalty. The execution rate for Pennsylvania up to the Revolution was one per year. In Massachusetts, up until 1660, there were 15 executions, four for murder, two for infanticide, three for sexual offenses, two for witchcraft, and four Quakers. Murder was a capital offense, of course, and so was rape, which included having sex with a child. Of course, if you were incorrigible and simply a chronic, quote, ne'er do well, you could be sentenced to death, as in the 1748 three strikes and you're out in Virginia if you were caught for the third time stealing hogs. But to stay biblical, unless you confess to a crime, it required two witnesses to condemn you. One of the stranger things about colonial justice was the use of an archaic medieval practice of Catholic priests called, quote, benefit of clergy, whereby if you could read from the Bible, you would be spared the death penalty. And the usual chapter read was Psalm 51, which became known as the neck verse because it saved so many from the gallows. Eventually, if you couldn't read, you could recite the memorized verse. In 1732, a Virginia law allowed women to invoke the benefit of clergy rule without reading. We'll continue talk about capital punishment in the South. Um, well, no, let me just go on with a few more things just for today. I do want to add some stuff. In the South, capital punishment was enacted more freely, especially on slaves. And while witchcraft trials were rare in the South, they were not rare in the North. The Salem witchcraft trial was unusual in its scope, but not rare. Confinement was not a normal part of colonial punishment as the actual sentence, but it did happen even though there were few cases. A society short on labor was reluctant to lock people up. The penitentiary system, prison, was basically a 19th century, the 1800s invention. No one in the colonies where repentance was valued more than confinement would have thought that segregating convicts with other convicts behind closed doors was better than having their noses rubbed in their sins in full view of their peers in the community. Jails were used to temporarily house prisoners, and since people were in prison for debts, they did use them for that type of confinement sentence. Rules for those in prison for debt varied in severity, and many were allowed to come and go as they pleased, only that they would sleep in the jail. You needed to provide your own food and bedding, and they were often allowed to beg to have someone send messages to loved ones. Okay, now we'll stop and we'll pick it up with additional information about workhouses, houses of correction, things like that. So I thank you for listening, and I hope you'll look into some of these things, come to your own conclusions, and study American history.